Yes, Your Honor. The matter before the court this morning is the case entitled Lillian Billewicz et al. Against Town of Fairhaven, Vermont, case number 23AP 267. The appellant is being represented pro se. The appellee is being represented by attorney Kevin Kite. And Your Honor, please note, because Ms. Billewicz is calling in, I will be giving all time warnings orally instead of via the chat function.
Thank you very much. Ms. Billewicz, could you hear me?
Yes, Your Honor.
All right, and we can hear you. You understand you have 5 minutes. Please go ahead.
Yes. Good morning, Your Honors. My name is Lillian Billewicz, and I address this court on behalf of myself, my son Jonathan, the J&M Investment Trust, and all Fairhaven taxpayers. The question before this court is, did the trial court err in dismissing the amended taxpayer suit for breach of fiduciary duty of a town official not collecting taxes and not funding the town coffers? These taxes remain delinquent because even as of today, no redemption period has begun to run because the select board never gave authority as required by law to bid. No bid was ever made, and the taxes remain due. We are here today to ask for review de novo of plaintiff's amended complaint and the four corner documents therein, which is the operative complaint and the sole focus for this court. Plaintiff's original complaint is functus officio, moot, and without any legal significance. The majority of defendants' brief and a part of the trial court's decision reference material which is outside the scope of this de novo appeal and must be legally disregarded from this court's consideration and decision. To substantiate this assertion, plaintiffs direct this court to plaintiff's reply brief at pages 4, 5, and 6 for case sites. Due to the limited time, plaintiffs rely on their brief and reply brief, yet emphasize the following sections and further highlight these parts. Addressing claim preclusion, the defendant states on page 28 of its brief, this court has been around this same block with these same plaintiffs before. This is not true. It is clear from the amended complaint, plaintiffs are coming forward as taxpayers and in a representative capacity of all Fairhaven taxpayers. According to Restatement Judgment Second, Section 36, 1980, and further bolstered by the reversal and remand of the U.S. Fifth Circuit Court of Appeals in Students for Fair Admissions versus University of Texas at Austin, the privity element of parties is not met where a party appears in an individual capacity in one action and a representative capacity in subsequent litigation. Therefore, the basic element of identity of parties for claim preclusion is not met, and the defendant's argument falls flat. In addressing statute of limitations, this Vermont court in Turner v. Sparrow acknowledged well-established law in Wellborn v. Whitney and distinguished it. This court, the Vermont court, respected the legal reasoning of that court concerning jurisdictional defects, acts without legal authority, and how no statute of limitations applies to void fatal defects. Plaintiffs again implore this honorable court to read Wellborn to legally validate that defendant's statute of limitations argument, again, falls flat. I reserve the rest of my time. Thank you.
All right. Thank you very much. We'll turn to counsel for the appellee. Please identify yourself and your client and then proceed.
Thank you, Chief Justice, and I please support. Good morning. My name is Kevin Kite. I represent the town of Fairhaven. It's difficult to respond to the arguments just because they strike me, frankly, as rather absurd. There is no claim for
Mr. Kite. I mean, whether or not they're, it's not really appropriate to characterize them as absurd. You might not agree with them, but I mean, the characterization is, I mean, can we keep it just as that you simply disagree with her legal
Yes,
analysis?
Justice Cohen, I apologize.
Well, don't need to apologize. It's distracting.
I disagree. The plaintiffs have provided no basis for the taxpayer suit they attempt to bring here. The law in Vermont is that if you're going to bring a taxpayer suit, you need to show that you have been harmed or that the public funds have been wasted in some way. This complaint simply doesn't include those allegations. They're not there. The complaint's very vague about which property the delinquent taxes are owed on. However, it's clear which property the taxes are owed on because just now, Ms. Billewicz referenced the tax sale of presumably 5 Union Street and 7 Union Street, which is the argument that was made in the reply brief and in the appellant's brief. That means that in order to establish the taxpayer suit claim that they're attempting to assert in this amended complaint, they're going to need to demonstrate that those taxes are in fact still due, which means that the argument will necessarily rely on showing that the select board had no authority to take its action. Once you're there, looking at whether or not the select board had authority to make a bid in 2014, you are deeply in the territory of statute of limitations, with including the general 6-year statute of limitations for Section 511 and the 1-year statute of limitations regarding tax collectors' acts. You are also deeply in the territory of claim preclusion because these arguments have been made many times in many courts, including once before in front of this court. If the claim is based on that 2014 tax sale, the claim accrued on April 1st, 2015, when the tax deeds issued in reliance on that tax sale. That means this particular lawsuit is out of time by at least 1.5 years. The argument that they are proceeding based on the interest of all taxpayers is not disagree with how you get there when the very property that is the subject of the repayment is the taxpayer's own property. That is not a representative capacity. And even if it were, even if they were proceeding in reference to someone else's taxes that had not been collected, the extent proceedings in the statute provide the mechanism for making sure those taxes are properly collected. And that mechanism has been left to government officials and not to private citizens. So there simply is no private right of action for this particular claim that they're attempting to assert. The rest of the town's arguments are sufficiently
Has 1 minute remaining.
Are sufficiently laid out in the appellee's brief, and will therefore rest on that brief unless the court has any other questions for me. Thank you.
Okay, thank you. I don't see any hands. So how much time does the appellant have, please?
Your Honor, appellant has 1 minute and 27 seconds remaining.
Did you hear that, Ms. Billewicz?
Yes, Your Honor.
All right, go ahead.
Yes, thank you, Your Honor. Now I'd like to address, if I could please, the statutory and fiduciary duty. Plaintiffs refer to their reply brief on pages 1 to 3 of the reply brief, specifically and emphatically on the entire paragraph that's in bold print. Plaintiffs will stress that there is a statutory duty in statute that's 4691. The collection of taxes is not a discretionary function. And in particular, I'd like to reference the Ozier v. Burlington case with the standard that was set forth and applied by this court, wherein it was cited the Board of Education of Oklahoma City versus Cloudman, that there is a fiduciary relationship between the taxpayer and the taxing authority. And officials and/or the town can be held liable for a breach of fiduciary duty when there is a legislative enactment for a duty, in this case, 4691. The Board of Education clearly states if a statute has been violated, there is a common law cause of action. The bad faith element. The town manager tax collector knew of his statutory duty, or should have known, violated it, and this taxpayer suit is viable on remand. The fact that there's a statutory duty does not obliterate a private action, common law action.
Okay, wrap your argument up, please. Your time has expired. Okay.
Oh.
All right. Thank you both.